This meeting of the Administrative Regulation Review Subcommittee will come to order. Please call the roll.
Senator Rocky Adams. Senator Thayer.
Here.
Senator Yates. Representative Bridges. Representative Fraser Gordon.
Here.
Representative Herron. Co-Chair Lewis.
Here.
Chairman West.
Here. We have a quorum duly constituted to conduct business. First matter of business is approval of the minutes. Do we have any additions or corrections to the minutes? Seeing none, do we have a motion for approval of the minutes? We have a motion. We have a second. Without objection, it is so ordered. Before we get started, any introductions? Special guests? Seeing none. Once again, if you want to speak in opposition to any regulation, we need you to sign up at the back. Please call the first regulation.
Office of the Attorney General, 40 KAR 1210.
40-1210 establishes application procedures, fees, and reporting requirements for participants of the regulatory sandbox.
If you would, please state your name for the record. If you can make sure that light's on there. Green. Nothing. Okay. Let's hold on just a second. Someone is coming your way. You two are the guinea pigs.
Testing. Can anybody hear that?
We can. Yes.
Check, check.
It's working now.
We're good.
Just in case.
We didn't push the on button, so there was a user error.
I wasn't going to say anything, but let's start from the beginning. State your name for the record, please.
Steve Humphreys, Executive Director of the Kentucky Office of Regulatory Relief.
Chris Boland, Executive Director of the Office of Administrative Hearings.
There are no amendments on this set of regulations. Do we have any questions from members of the committee on this set of regulations from the Office of the Attorney General? Seeing none, please call the next regulation. Thank you.
Thank you.
Thank you.
Personnel Cabinet, 101 KAR 286. This regulation has a staff suggested amendment.
101 KR 2086 establishes the internship interview preference for certain applicants in certain executive branch positions if applicants meet certain minimum qualifications in KRS Chapter 18A and can provide documentation verifying successful completion of an internship coordinated by the Personnel Cabinet. The staff amendment amends various sections to comply with KRS Chapter 13A.
Would you please state your name for the record?
Rosemary Holbrook, General Counsel.
Jamie Caldwell, Commissioner, Department of Human Resources Administration.
Thank you so much. There is a staff amendment. Do we have a motion for approval of the staff amendment? Do we have a second? Without objection, it is so ordered. Any questions from members on this set of regulations from the Personnel Cabinet? Seeing none, please call the next regulation. Thank you.
Thank you.
Teachers Retirement System, 102 KAR 1320. This regulation has a staff suggested amendment.
This regulation is being amended to establish the requirements, procedures, and forms for the approval and processing of qualified domestic relations orders. The staff amendment amends various sections and the material incorporated by reference to add clarifying language, make technical changes, and comply with the drafting requirements of KRS Chapter 13A.
Would you please state your name for the record?
Yes, good afternoon. Bo Barnes. I serve as Deputy Executive Secretary and as General Counsel for the Teachers Retirement System.
Thank you so much. There is a staff amendment. Do we have a motion for approval of the staff amendment? We do. Do we have a second? Without objection, is so ordered. Any questions from members of the committee on this regulation from the Kentucky Teachers Retirement System Finance Administration Cabinet? Seeing none, please call the next regulation. Thank you.
Thank you.
State Investment Commission and Private Activity Bond Committee, 200 KAR 1411, 81, and 91, and 200 KAR 1510. All regulations have staff-suggested amendments.
200 KAR 1411 amends to require nationally recognized statistical ratings organizations to be commission-approved before having opinions followed, allow deposit of additional funds into a mutual fund for the short-term pool only, remove some limits on composition of the investment pool, and increase mandated assets under management of approved broker-dealers. 200 KR 1481 amends to mandate review for sufficiency of collateral will occur on every business day rather than once every 7 days, and increase the allowed repurchase agreement with a commercial bank from $25 million to $50 million. 200 KR 1491 amends to retain the same limits on all investments in bankers' acceptances, commercial paper, and negotiable certificates of deposits, but relocate the limits to Section 5 of the regulation. The staff amendments for 1411, 81, and 91 make changes to comply with CARES Chapter 13A. 200 KR 1510 amends to generalize specific references to the federal law to an additional federal volume cap. Remove in the material incorporated by reference section specific references to edition dates, and update contact information, including a link where the material may be found. And the staff amendment makes changes to comply with CARES Chapter 13A.
Please state your name for the record.
Chelsea Couch, Director of the Office of Financial Management.
Ashley Daly, Staff Attorney, Office General Counsel of Finance.
Thank you so much. There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion. Do we have a second? Without objection, is so ordered. I'll have one question, then I'll open up to members of the committee. I'm asking you this question because I don't know what it is. Okay, so in 200 KR 15010, where it talks about American Recovery and Reinvestment Act to additional federal volume cap, what is that talking about? It is 200 KAR 15010.
So this regulation establishes the formula for the allocation of federal tax-exempt activity. Is he asking about this? We removed the American Recovery and Reinvestment Act of 2009 to establish some framework for any other federal stimulus packages that may come in the future.
Gotcha. Okay, so the state is preparing itself basically for any possible new allocations, or if they're named something else.
Correct.
Gotcha. Okay. Any other questions from members of the committee? Seeing none, please call the next regulation. Thank you.
Board of Pharmacy, 201 KAR 2370 and 480. Both regulations have staff-suggested amendments, and 370 also has an agency amendment.
201 KR 2370 amends to exclude assisted living communities from the definition of long-term care facility, define tamper-resistant secure container, update material incorporated by reference, and make changes to comply with CARES Chapter 13A. 201 KR 2480 establishes definitions, requirements for pharmacies located in Kentucky engaged in remote prescription processing, electronic supervision, confidentiality, use of technology, security, policies and procedures, record keeping, and prohibited practices. The staff amendments for 201 KR 2370 and 480 make changes to comply with CARES Chapter 13A. The agency amendment for 201 KR 2370 amends to comply with CARES Chapter 13A, amends Section 1 to exclude from the definition of long-term care facility assisted living communities as defined in statute, and amends Section 2 for consistency with the categories of assisted living community licensure as established in statute.
Would you please identify yourself for the record?
Sure. Chris Harlow, Executive Director.
Eden Davis, General Counsel.
Thank you so much. There are staff amendments. Is there a motion for approval of staff amendments? There is. Is there a second? Without objection, is so ordered. There is also an agency amendment. Are there any questions or discussions on the agency amendment? Seeing none, is there a motion for approval of the agency amendment? Motion. There is a motion. Is there a second? Without objection, so ordered. So we have the regs before us as amended by staff amendments and an agency amendment. Any questions from members of the committee on this set of regulations from the Board of Pharmacy? Seeing none, please call the next regulation. Thank you.
Board of Dentistry, 201 KAR 8563, and this regulation has a staff suggested amendment.
201 KR 8563 amends provisions to clarify that a dental hygienist licensure applicant may complete required clinical examinations or be credentialed in another state or territory of the United States to be licensed, address reinstatement fees for expired licenses, clarify that a dental hygienist administering local anesthesia shall do so under the direct supervision of a dentist, and incorporate additional material by reference. The staff suggested amendment amends Section 6 to make a correction consistent with statute that dental hygienist licenses issued by the board expire on December 31st of even-numbered years, amends fee language consistent with 201 KR 8520, and makes technical corrections to comply with the drafting and formatting requirements of KRS Chapter 13A.
Would you please state your name for the record?
Of course. Jeff Allen, Executive Director.
Thank you so much. There's a staff amendment. Is there a motion for approval of the staff amendment? We have a motion. We have a second. Without objection, is so ordered. Any questions for the Board of Dentistry? Seeing none, please call the next regulation. Thank you.
Board of Licensure for Professional Engineers and Land Surveyors, 201 KAR 1810, 30, 115, 192, and 196. All regulations have staff suggested amendments.
201, 18, 030, 115, 192. Revised provisions for professional engineers and land surveyors, including for classification, in-training certificates, license reinstatement, and continuing professional development. The staff suggested amendments amend various sections to comply with KRS Chapter 13A. 201, 18, 192, and 196 are also amended to add incorporated material.
Would you please identify yourself for the record?
Kyle Elliott, Executive Director.
Jake Miller, General Counsel.
Thank you so much. There are staff amendments. Do we have a motion for approval of the staff amendments? We have a motion. We have a second. Without objection, is so ordered. Do we have any questions for the gentleman from the Board of Surveyors? Seeing none, please call the next regulation. Thank you.
Board of Interpreters for the Deaf and Hard of Hearing, 201 KAR 39 1, 30, 40, 50, 60, 70, 75, 90, 100, 120, and 130. All regulations have staff suggested amendments.
201 KR 39 1, 040, 050, 060, 075, 090, 100, 120, and 130 amend and clarify definitions, separate requirements for full licensure and temporary licensure, establish provisions relating to the supervision of a temporary licensee or a licensee under discipline, increase licensure fees, amend complaint procedures to remove references to a case manager, remove provisions relating to a waiver or extension of continuing education, establish a registry for non-resident interpreters to register services provided in Kentucky, and update material incorporated by reference. 201 KAR 39030 proposed removing the Educational Interpreter Performance Assessment, EIPA, as a qualification for full licensure, and giving licensees with EIPA passage 5 years to obtain a national certification to remain fully licensed. The amended after comments version amends Section 3 to grandfather in interpreters with EIPA qualifications licensed by January 1st, 2025, as long as they annually renew the license. 201 KR 39070 proposed removing language relating to the reinstatement or extension of a temporary license, including provisions relating to the appeal of a denial of a temporary license, and adding material incorporated by reference relating to temporary licensure. The amended after comments version reinserts language establishing a process by which the board may authorize a 1-year extension of a temporary license in specific circumstances, and makes conforming amendments to material incorporated by reference. The staff suggested amendments make technical, formatting, and conforming amendments to the administrative regulations and material incorporated by reference consistent with KRS Chapter 13A, other statutes, and other administrative regulations.
Thank you. Would you please state your name for the record?
Marva Johnson, Chair, Kentucky Board of Interpreters.
Thank you so much.
And Sarah James, I am staff attorney for the Public Protection Cabinet, Office of Legal Services, and I'm board counsel to the Kentucky Board of Interpreters for the Deaf and Hard of Hearing.
Thank you so much. There are staff amendments. Is there a motion for approval of the staff amendments? Motion. We have a motion. Do we have a second? Second. We have a second without objection. So ordered. We're going to do things a little bit differently in this segment. There seems to be some issue around 39030. So I'm going to ask members of the committee, does any member of the committee have any questions on any regulation other than 39030? Okay. Seeing none. Oh, yes.
I just had
Please proceed.
Okay, thank you. I just had some general questions as far as how many people do you license, or how many interpreters, or how many?
Right now, there's 533 fully licensed interpreters and 45 temporary licensed interpreters.
Okay, and how does this relate to as far as the need across the state? Do you feel like this is an adequate number, or we need more? Too many? How does that relate into?
Honestly, there's a national shortage of sign language interpreters, so I would say that Kentucky's not unique in that.
Okay, and then my last question, if I may, do you think that these regulations are going to help towards this shortage, or possibly create more of an issue?
That's a loaded question because other things are at play besides the actual licensing. I don't believe it's going to harm nor help, if that answers your question. No.
So if you don't mind, Representative Frazier, let's circle back.
Okay.
So you'll see where I'm going in a second.
Okay.
Let's, if you don't mind, on 39030, okay, if you could go into that, just describe to the committee kind of where we've been, okay, and then what this reg is and what it's attempting to do, just the 39030.
Okay, sure. Actually, I would like for Sarah to speak on the statute that.
Sure. Yeah. Whoever wants to speak can chime in.
Okay.
Yeah.
And go ahead.
Okay, thank you very much. And I apologize because my eyes are shift. You know, I'm looking at two screens here because I can't look down at my paper. But 030 is the regulation relating to full licensure. One of the changes was that it was a bit confusing because at one time it related to both full and temporary licensure. And KBI has a policy committee that is statutorily created. And they made some recommendations relative to this to sort of separate things out and to streamline. But what prompted a comprehensive review of this regulation set, I would say, was that there was a change in the credentialing organization, the names of the testing. And so this regulation establishes what it takes to get a full license. What in the certifications that were held. It was very restrictive, and because of the names changed, there were people who actually qualified that the board has not been able to approve for the last period of time preceding me coming to work with the board because the names have changed and the new certifications weren't authorized by the regulation. So that prompted one change to it. It also talks about, the appeal of a denial and the and basically just, that's what that regulation initially did. And the amendment, when we got into it and started working through it, the discussion led to wanting to qualify full licensure with an EIPA to K through 12 settings, which led to the realization that the agency or the organization that is responsible for EIPA does not recognize EIPA as a certification. They're not a credentialing or certifying body. And by statute, the board is limited. The board is limited to granting a license to only people who have a certification by a national organization. So that's sort of the history of how we got to the board's decision to eliminate EIPA as a qualification for full licensure, because it is not, nor has it ever been, a certification by a nationally recognized organization. It was at one time by the Registry for Interpreters for the Deaf. And I'll let Marva explain that piece a little bit, but they changed their stance on it in 2017.
So thank you, Sarah. The Educational Interpreting Performance Assessment was developed by Boys Town, another organization.
Could you pull that mic just a little bit closer?
Sure.
Thank you.
Do I need to start again or? No, okay. And the organization, the purpose of developing this test is because when the least restrictive environment came about and deaf children were going into K-12 settings and what we call mainstream settings with administration that didn't have the tools to assess what an interpreter should do in the classroom. So Boys Town created the assessment, and the assessment was never intended to be a credentialing. It was the purposes was what your results you could take to administration and say, I can function in a classroom. Well, since then, then our national organization, the Registry for Interpreters for the Deaf, did recognize the EIPA as a certificate from the years 2012 to 2017. And the purpose of recognizing it as a certificate is so those interpreters could have access to our CMP, which is our system for keeping up with CEUs, and they could be a member of our organization. 2017, and I've served both on local boards and national boards. So in 2017, the board decided to no longer award the certificates because it caused great confusion within our field as people were, with just the certificate, were saying they were certified, but it's separate than what you actually, the testing, the pass-fail test system to actually be considered a generalist interpreter. So RID, the people from 2012 to 2017, they still are acknowledged to have the certificate, but they no longer give the certificate name on people that pass the EIPA at a certain level. So it is not recognized nationally. EIPA, first, Boys Town does not. I'm sorry, I'm very nervous. This is,
Take your time.
Boys Town has stated that it is not a credentialing assessment. It is not a credentialing tool. It's basically a place for where interpreters can go and determine where they're at and where they can improve, which it has a place, but our full licensure says certification, and once you get your full certification, that makes you a generalist, and we also have other tracks that you can go. You could get a specialty certificate in legal, which now has been sunset, but that was after you became certified. You can get a mental health, MHIT, mental health interpreting, not the MI, it's a Q, qualification for mental health. And that is once you become the generalist certified, and EIPA would fit in nicely after you have passed the point of where you're a generalist interpreter, and that would fall under another system if they would require an EIPA, which I would say the education system could require an EIPA before those interpreters come into their classrooms. But by statute, each interpreter should have a certification from a nationally recognized organization.
That sounds good, and it sounds really complicated. Like it's
welcome to our field.
But yeah, clearly it's a struggle within, to make sure the credential means the same thing is what you're shooting for. But just to try to sum up, I'm going to open it up for questions here in just a second. But just to clarify, we're going to have a woman get ready to testify against this regulation. But just to kind of sum it up, kind of what I'm hearing from others is the crux of the disagreement may be that some of these people who are already licensed in the system under EIPA, they would have a 5-year term to
actually
correct me. Tell me where I'm wrong.
Actually, during our comment period, Senator Boswell submitted a comment agreeing with our changes, but had asked if we would consider grandfathering those 22, or it was 21 at the time.
Right.
And as interpreters become, we can't not tell somebody they can't have a full license at this point because the new regs aren't in place. So anyone that meets that standard would come in, be grandfathered in, and wouldn't have any more requirements after that. Prior to that, we did have the regulation stated that we would give those that have an EIPA performance score of 3.5 or 4.0 5 years to get to the national certification level. And after the comment, we decided that those 22, as long as they continue their professional development, they can continue with their full license.
Okay.
Right. We amended after comments, if I could just, and another amendment after comments to this reg was to ensure that it came through comments that there were some new credentials that may, certifications that may be on the horizon, specifically related to education. And so we added language that any current certification from a nationally recognized organization at the right levels that are required by statute could be approved by the board. So we put in sort of a kitchen sink provision that anything new, so we're not as limited and restricted as the board has been up to this current point. And then it is the 22, but anybody else who, I don't expect that these regulations will go into effect before the first of the year. So any applicant with EIP only who is issued a license between now and the effective date of this change would then be grandfathered in permanently, so long as they comply with their annual renewal requirements. If somebody doesn't renew as they're supposed to, then the new, any reinstatement, they would be expected to have a national certification. So they have to stay on top of it.
Okay. I was confused. The document I'm looking at is the original document that had the 5-year provision in there. And I don't have in front of me the amended after comments version. So just... Yeah, it's not in here. Yeah, you won't see it up here. But for clarification, the 22, 25 people that already have this EIP licensure status, if this moves forward, they will be grandfathered in. That group will be grandfathered in.
Yes, sir.
Not have to worry about the 5-year.
No,
permanently, sir. Yes.
Gotcha.
Correct.
Okay, I was confused because any other members have questions? We're gonna, a lady will be here to speak against. Any questions for the board? Okay. At this time, we will bring Mrs. Bozeman up. Linda Bozeman.
Do I stay or?
If you don't mind moving over one,
Sure.
if that's okay. Hopefully you two won't battle it out too much. Keep your hands to yourself. And
Can we hug?
whenever you're ready, please state your name for the record and proceed.
Hi, good afternoon. I'm Linda Cobb Bozeman, certified interpreter, licensed interpreter in Kentucky. And I am objecting to the current regs as they are stated.
Just for clarification, are you specifically talking about 39030?
Correct. Related to the EIPA.
Please proceed.
As past president of the KYRD, as past board chair and the original board chair when licensure was instated here in Kentucky, we reviewed a number of possibilities to become licensed in our state. And at that time, we had both the National Association of the Deaf and the Registry of Interpreters for the Deaf that were certifying, quote unquote, certifying individuals to become certified. We reviewed all of those requirements and wrote out the initial regs as they stood. As the years went on, RID went through a number of changes and was in a constant suspension of the testing that they had in place when they developed a new test. And as an example, I currently hold 6 different certifications from RID because of the changes that have happened over the years to become, to meet that current standard. I taught at the university. I felt like I needed to be on top of what needed to be in place. During that time, we found it necessary as a board to look at other alternatives while testing was suspended. EIPA came into play. After much deliberation, we looked at their reliability ratings and the like and accepted EIPA. During the same time, RID accepted the EIPA as a certified level if you attained a 4.0 or better. So we've changed our requirements from 3.5 to 4.0 to match what the national organization said was certifiable. My concerns now are, I do appreciate that they listened to the comments that were made. I think there was over 140 concerned with the changes that they were going to be putting forth. And
Could you stop right there?
Yes.
So from prior testimony, the universe of people is around 500?
Correct.
Is that, and so theoretically of those 500, a lot of those, 140 would be a large portion of the 500, correct?
Correct.
Okay. Thank you. Please proceed.
Give me a moment. I'm trying to think where I was at.
I apologize.
No, that's quite all right. So the RID accepted a 4.0 on the EIPA as a certified level, stating that that was acceptable. They have since put that certification into, I'm not sure if I'm saying the right word, Marva, moratorium, that they have okay, it's not used as that term, but in essence, they have sunset giving that certificate to those individuals. My concerns are that we have 22 individuals who meet that standard for EIPA that may be considered and grandfathered in, but with the shortage of interpreters that we have nationwide and in our own state, where currently we do not have the interpreters in place to fill open positions in K-12 settings in our state. Currently, there are 28 counties that are looking for interpreters to fill those positions. We can't find them. We don't have enough. And to limit those individuals by saying, no, you can't, they corrected that by having that grandfathered in. That's helpful, but it also limits anyone that comes into our state that would like to apply for a position that holds an EIPA of 4.0 or better. It prevents them becoming licensed in our state to work. We are in desperate need of interpreters in K-12 settings. Our students deserve qualified individuals in those positions, and my contention is that we need to allow that to continue on. There was some concerns that individuals that hold this certification were working in the community, which their certification does not certify them for. They are certified for K-12 settings, but we address that in our code of ethics that states you do not work outside of your realm of certification. So if I'm certified as K-12, that's where I need to stay. And I would like the board to consider expanding that anyone that comes in with a 4.0 or better on EIPA would be considered licensed in our state in order to be able to achieve the needs and fill those positions so they come available for our individuals in the K-12 setting.
I've got one question. So, what does KDE do? What do they require? Do they require overall licensure, or for instance, the scenario you're talking about? Somebody comes in from out of state with an EIPA, ready to roll, ready to go to work in a K-12 setting. Does KDE regulation preempt them from working?
The KBI regulation would exempt them. One of the things that when we initially set up licensure was that
so if it would be okay with KDE, but
KDE does not have any regs, to my knowledge, that address this.
So they're silent on it. Okay,
they are silent on it. They
but
work
the board,
guidelines.
you're practicing without a license, basically, in the
Correct.
state. Gotcha.
Correct.
Gotcha. There's your. I'm with you now. I'm with you now.
And so that's our concern. Is that if we did have people come in from other states that were qualified under the EIPA as it stands now, they would not be able to get a license and therefore could not practice in our state.
And
My
so
other greater concern.
Go ahead. I'm sorry.
Our other greater concern, sad to say, is that I think a number of school districts have slid people in under the radar, so to speak, by not calling them interpreters, by calling them something other than an interpreter. They're an aide, they're an assistant, they're whatever in the classroom. And so we are aware that that may be going on in the state. But when you have a child in the classroom who uses sign language as a mode to communicate, we want them to have the best possible scenario, and that is to have someone in there that is qualified to be able to interpret for them in the classroom. And I believe that the EIPA at a 4.0 or better for full licensure meets that requirement and that threshold, as it was recognized by RID and as demonstrated through the validity and reliability standards that were in place for this test to be in existence when we accepted it initially.
So what would your solution be? Keep it the same? Or what do you have
My recommendation is that those who are currently in with a 4.0 and anyone else that may come in with 4.0 using the EIPA, that they would be recognized as fully licensed for K-12 settings.
Very, very important distinction, just for K-12 settings.
Their credentialing says K-12, and our code of ethics say that you will work in those areas where you are credentialed. And by default, if someone does not, they can be a cease and desist or any of those kind of charges filed against them should they go beyond what their scope of certification.
So you're asking for a carve-out K-12 here.
Correct.
In the reg. But other than that, you're okay if it all moved forward.
Yes, sir, I am.
As is. Okay. Thank you so much. Any questions from members? I think Co-Chair Lewis, do you have a question?
Thank you, Co-Chair West. I have a question going back to Marva and Sarah. When these regulations were promulgated, just in my research, how many members did you have on the board at that time? 4. And it's a 7-member board, correct?
Yes.
There were 4 members on the board at the time that these regulations were passed. It was unanimously. So it met statutory quorum.
And it was unanimous in the vote itself?
Yes, sir.
Okay, thank you.
And Senator Wentz, could I disagree? I don't believe that was unanimous.
It was unanimous.
In May, it was unanimous. That was when they were initially voted upon, and it was unanimous.
Okay, they've said it's unanimous. You're
At
free.
the September meeting, it was a split vote.
Yeah, at the September meeting, that was a meeting on the comments, amended after comments version. But the regulations were filed in June, and they were approved by unanimous vote by the board in May at its regular meeting.
Okay.
Committee will stand at ease. Do any other members have questions on any of these regs? Representative Frazier Gordon, sorry, I didn't see.
I would just like to know, do you have a response are you in agreement, or what would be the issue with the carve-out, or could you comment in regards to her suggestion?
Sure, yes. Well, first of all, the carve-out wouldn't be possible unless we changed the statute, because the statute says nationally certified, recognizing nationally certified credentials. And as I stated, Boys Town has said that this is not an assessment to be considered for credentialing. And I would like to, if I could, address
Please proceed.
Someone moving in from another state, and that's one of the issues with it not being a credential. Someone could have tested a 4.0 10 years ago with the EIPA, and because it's not a credential, you're not tied to any association or professional body. So you can pretty much have the 4.0 for 10 years and not have to take any professional development, have no accountability to anyone. So sure, they can come over and now get a full license and be able to sit in a classroom with a child with emerging language that has already probably experienced some type of language deprivation, and they have had no training in 10 years. And if you know anything about not just sign language, but any other language, if you don't use it, you lose it. So that's one of the other issues with EIPA not being tied to a credentialing body.
And I would just also like to add that, in 2012, we've had 12 more years have passed since that time. I mean, there have been some studies relating to, the standard, the quality of education for children. But, so there's been some studies that have been done since 2012. And at the time and I think at the time, based on the circumstances the board was presented with and the opportunities and then the Registry for Interpreters for the Deaf, it was reasonable for the board to include the EIPA. But since that time, things have changed considerably. And I don't believe that the board can do a carve-out absent a statutory change, authorizing the board to, there was some of the comments included an educational interpreting credential, an education interpreting license. And the board would, I'm sure, willingly do that, but they need statutory authority to do it. And that would require a legislative change, authorizing the board to do it.
Follow up.
Yes, please proceed.
Could you comment in regards to the board makeup? I understand it's a 7-member board, but at the time that these were passed, it was the 4 members. Like, who was on the board?
Yes, ma'am. At the time, well, if I could back it up even further, when we first started working on the regs, began the work on the regs, we had a regulation committee, which consisted of myself, Nina Coyer, and Rebecca Kreutzer. And at that point, I believe we had 5 members on the board, and then Nina, who has been around for many years. She's a certified deaf interpreter, and 2 of our seats require a certified deaf interpreter hold one, and then a consumer of service hold the other. So we don't have any other certified deaf interpreters in the state that could fill that seat, and Nina retired, so we went down to 4. But she was very involved in the development and the discussions around what should be changed, and was actually her and 3 of us, it was myself, Reb, and Nina, the 3 of us agreed that this was the best action to take. She retired. It took us to 4. We waited to have more people appointed to our board. It didn't happen. We continued on. We also, by statutory requirement, we have a policy committee, and the policy committee is a makeup of stakeholders. I believe KDE actually is one of the stakeholders in that policy committee. They came together, had several meetings. Once they had suggestions in place, they brought it to the committee. We actually met with the policy. They brought it to the regulations committee. We met with the policy committee twice in person and virtual, hashed out some of the points, because this wasn't the original, and we came to some agreements with our stakeholders, and it brought us to our May meeting where we had presented it to the board. The committee presented it to the board. We talked about it at that entire meeting, and it was unanimously voted to move forward.
Okay, so thank you for the detail. But in general, so there's 6 interpreters and 1 consumer that comprise the total 7-member board?
Yes.
And 2 of the interpreter positions, have they since been filled?
We have 6 now, yes.
Okay. Thank you.
Senator Yates.
Thank you, Mr. Chair. Thank you both for presenting. And whenever we kind of go back and forth, I naturally try to be a problem solver and see how we maybe resolve it. A lot of times in these hearings, we hear about how in Kentucky that we're forced to lower our standards in order to be able to compete, not just in this committee, but across with from different educational models, from CDL requirements, from all these different things. And it is sad because you want to be able to be proud of what we require, but all of a sudden we know we keep cheaping our model. And so I worry that any time that you will loosen or otherwise bring it outside, sometimes you can cheapen a higher certificate or qualification. With that being said, I don't know enough about this particular, whether or not that's the case. The fear, it sounded like a minute ago, was that if someone has an EIPA certification and it's high level, that normally that's okay, except for extreme circumstances that maybe someone hasn't practiced for a decade or have been out of it. It seemed like that's an easy fix. Somewhat, we put it, you could make a requirement that somehow that they have that certificate and that they've had, corresponding continuing education or corresponding, some other additional requirement, if that is really a big number. So my real question is, maybe in the past couple of years, how many people have come from out of state with this EIPA certification to come work here? If that's a lot of people, if it's even a real issue. And then if that is, we're worried about the future, well, if we've known that this has been something that has not been a problem in the past, maybe we make that qualification that not only they have that, but they have corresponding education. And if it takes a statutory change, you've come to the right place where the people that can do it. But anyway, I just wanted to put that out there, and maybe you guys could give me a feedback if that's something that's doable.
I do have something I would like to add.
I appreciate that.
If I can.
Please proceed.
So I did want to clarify one thing, because I don't think we've made this point and we need to. EIPA remains a path to full licensure, because EIPA, and they did put a qualification in these amendments that they need to have achieved the score within the last 3 years. That makes it more recent. They can obtain a temporary interpreting license. So in the instance where, and I don't know that we could pull the numbers of the number of people who've applied from out of state, that would probably be something that would have to be done, manually, for lack of a better term, looking at all the applications in the last period of time and look at each one individually to see where they were coming from. But, and there's a lot of people with the EIPA credential who also have other types of certifications. Mm-hmm. But I just want to make sure that the committee knows EIPA is a path to full licensure, because you can have an EIPA of a 3.5 or better and get a temporary license and hold that temporary license for 5 years if you're a hearing interpreter and 10 years if you're a deaf interpreter, while you are achieving your national certification. And then they've also thrown in a 1 additional year extension on top of the 5 or 10 years for that person to get their national certification. So the person could still come to Kentucky and provide the services with a temporary license. They're just eliminating it as the qualification for full licensure by itself, because it is not a certification from a nationally recognized organization as is required by statute.
May I respond to
yes,
Senator Yates?
Please proceed.
I appreciate your comment around the difference in certifications and certificates and how it does, it may lessen the value of one over the other. And I think this speaks to the shortage that you asked previously about. Right now, across the state, being recognized as an interpreter in the school setting is difficult, and it varies on county by county. Some states recognize them as a paraprofessional, some recognize us as certified interpreters, and you will see the difference in pay as well. Certified interpreters get paid more than what an EIPA person is, and that may take care of some of the shortage, because we do have certified interpreters out there, and a lot of them do not go. Yes, they want to be in the K-12 setting to work with children, but because there's no standardization across the board, because you have all these differing values within the certifications and what you hold, the pay reflects that. So hopefully this will help. And believe me, I do think there's a place for the EIPA. I just don't think it's a place for the generalists coming into our field. You should have that before, and then go and take the EIPA, because basically the EIPA assessment is an assessment. You go and take it, and it's on classroom material only. And we know that children do not just function in a classroom. There's social language, there's other situations that go on throughout the day besides classroom materials. And that's what the EIPA tests over. And then once you get your results, they give you a great feedback on it, and then you can take that feedback and go take the test again and keep taking it until you achieve this number. So I'm sorry about my passion. I'm sorry.
Did you have a comment?
Yes, I just wanted to respond to Senator Yates earlier. When you look at Kentucky and our interpreting standards, we far exceed the 7 surrounding states. We have licensure in our state. The other 7 states do not. So they look to Kentucky as setting our standard. And I agree with Marva. We do an excellent job of even having that in place, and we take great pride in the fact that we serve our people in our state with qualified individuals, whether it be in a generalist setting, in the hospital, the doctor's office, in the workplace, etc. Kentucky exceeds all 7 states. So I stand proud that we do that. I just want a mechanism for those individuals who are coming in with an EIPA that come from other states to meet our shortage, that they be allowed to do so in a way, because oftentimes it's like you need to be fully licensed to work. And so by limiting them to the 5-year period, in 5 years, and I'll just say this, the testing is stringent. Getting into the testing system in Kentucky, there is no place for them to take that currently in Kentucky. They have to take that expense of going out of state to take the test, and then to get those results back. They are catching up. RID is becoming much better, but it has taken as long as 2 years to get the results. So if I'm in a 5-year window, I've used 2 or 3 of my years to prepare. I take my test. I'm at the end of my 5 years, and it takes me 2 more years to get my results. I'm out of a job because I'm no longer licensed. So that's my concerns with that as it stands right now. We have people, what I call in the system, that are graduates from ITP programs in our state who started on the EIP track, so to speak, working toward that, or any number of tracks that we currently have available in our licensure. And as they've gone through that, they've taken tests, paid for those tests, got those assessments, and now we are changing the rules, so to speak, for them, that EIPA is not an avenue for them. So they're having to backtrack, retake tests to qualify for the RID, the CASLI RID test. It's a different knowledge skill-based test. It's a different skills test. So they're having to repay for those. So already out of pocket for getting licensure and that trail, and now I'm out another $1,000 to $1,500 to take an additional test now. It seems cumbersome upon those individuals who are already in the portal to get there.
Senator Yates has a follow-up.
All right. Thank you for that, and that was a lot, and I appreciate that.
Sorry.
That's okay. I had a couple, and thank you for that clarification. And a lot of times these committees, we're here to learn, and I appreciate it. When we first started off, we talked about that we didn't have enough people, and there was unfortunately, that we have lots of parts of Kentucky that are not being served, that otherwise be an underserved population. I know that we've had issues. I know we've had issues in the legal system, and so I do think the certification is important for some of those standpoints. And so I do appreciate, I guess, that we're doing better than the 7 states around us. But I think we started off this saying that we don't have enough. and we need more, and we're proud of our certification, our quality, and we don't want to do anything to diminish that.
Correct.
So it's kind of like both. We're saying that and I'm with you. I don't want to diminish that because I've seen us do that over and over again. And so when you said that this is a pathway, and that makes some sense. It's kind of like getting, I guess, your undergraduate degree and then moving on. And, okay. And if it's not fair to obviously we have to have, you want people to continue to move and advance and become the best they can in the profession, but you don't want to do it in a way that the state and the agencies help provide that. If it's taken too long, you potentially could have a moratorium that stops that clock from ticking from the time they take the test when you're waiting for those results back. Sometimes if it takes a year or so, that could block that off. There's simple solutions usually for this. Or there's some type of initiative. The place to take the test is, I guess, it's a national test, so it's not done here. Do you have to travel far outside of the state, I would think, to do that? Or if there's any ways that we could try to cheapen that cost. Again, this is kind of a problem-solving in situation. If there is an issue, and I think everybody said that we think we have an issue, I just want to know how big it is. And they said that it may take too long to take. I mean, how many, or do we have thousands of applications each year? And then would it take that long to look at it, to find out? Okay.
I would like, if I could, address the time, because that has been a point of contention in our field, and it was a perfect storm, okay? So our national organization, the test goes through, if you know anything about testing, the tests go through cycles itself, and about every 5 to 7 years they are revised. So right before COVID, it was time for our national test to be revised. And then we had COVID. So it put everything on hold for our test to get revised, developed, and then when we came back from COVID, we had to go into a beta phase, which did extend the time people were getting their results, where the board also worked with those people and granted extensions. The national organization gave time back to people in between their tests, because there's a certain time frame. You have to take the knowledge test, and then you have to take the performance. So there was things put into place. Since we're out of COVID, test results are coming back within 3 to 6 months for our national certification. Now, what has happened is the people that couldn't take the national certification have now went and took the EIPA. Now, the EIPA is taking up to a year to get results back on that. So it's if you continue on the track, that the track of getting certification, 5 years is plenty, because our national certification, for you to sit for the performance test, you have to have a bachelor's degree. EIPA doesn't have any prerequisites. And within that 5 years, you should be able to finish your education. And we have a supervisor system set up where you're supervised by, we previously called them mentors. You are mentored for that 5 years to get to a place of becoming certified. The same with the EIPA. If you choose to go the EIPA knowledge route, you take another performance test, you still have the same 5 years. However, you don't have that requirement of having any prerequisite, any education, and these are the folks that are going in to work with our children. And we are, our responsibility as Kentucky Board of Interpreters is to protect the public. And that's one way we can protect the public, knowing when we send an interpreter, when an interpreter goes out to an educational setting or any other setting in the environment, medical, legal, what have you, they are licensed with a fully certified, and that's what the statute says, a certified, recognized by a national organization.
I think any other questions from members? I got a few here to wrap it up. How long have we had EIPA as a qualification?
Since 2012. The regulation was amended in 2012.
2012, okay. Was EIPA nationally recognized in the past?
RID included, because the members, they could be a membership, RID would verify EIPA, that qualification on its verification form. until 2017. They stopped because they acknowledged that it was not a certification.
Okay. Here's where I'm confused. So the reason we can't do the carve out supposedly is it's not nationally recognized. Okay.
It's not a certification, right?
And so the statute that requires it is KRS 309-312, which says current certification from a nationally recognized organization. Okay.
Right.
So this statute, it appears, was passed in 1998.
Correct.
So where I'm confused is we've done this for 12 years. And so why can't we continue to do it? We want to comply with the statute.
Mm-hmm.
It appears we haven't complied with the statute for 12 years. So why is there a rush now to not do a carve-out?
Well, again,
is that the only reason, I guess, is that?
In 2012, RID acknowledged it. Therefore, it was recognized by a nationally recognized organization. Right. In 2017, they put a moratorium on it, and they no longer. So since 2017, it's not 12 years. It's whatever, I guess. 12 minus 5, so 7 years.
7 or 8 years. Yeah.
Yeah, 7 or 8 years. Yeah, I don't do that. So I went to law school because I can't do it. But
I understand.
But I don't think
if I may.
Yeah, please, Marva.
EIPA, and I know it's a little bit of a different. EIPA was never recognized as a certification. It was a certificate, and if you accomplished whatever RID required at the time, you were able to become an associate member, not a certified member. You were an associate member, meaning you paid dues to the organization, you had access to our professional development, and you had access to a system that would keep track of your professional development. And that started in 2012. And then they backtracked in 2017 because it caused so much confusion. People were thinking certificate meant certification, but it did not. So, and I believe in 2012, when the regulation was developed, that may be some of the reasoning behind that regulation. Gotcha. Because there was national confusion over it. RID acknowledged it and did a repair and moratorium, and that's why it was important to say sunset, because this will no longer be recognized moving forward. A moratorium is just a hold until we figure things out.
Gotcha. I think I can wrap all this up. Does anybody else have any questions? Okay. We've spent a lot of time here, so this is very, very important.
I appreciate it.
Which is why we spent a lot of time on it. I've got a bit of a proposal as this committee chair. So it sounds like we've done this same thing for about 7-8 years. The status quo has been in place about that long. And so we're going to have a real problem. I'm also chair of education, so we need people in classrooms doing this type of work, and they need to be licensed. Okay. And so in all other occupations, there are different carve-outs for different levels of that particular occupation. Like you have an MD, a physician's assistant, a registered nurse, and on and on. So it's clear that there could be some type of carve-out for someone in the education space. Okay. So we're literally a month or so away from session. And so if we have a member of the General Assembly who wants to file a piece of legislation to allow a carve-out, if we got into session, we could do that. And so my ask is to the agency is, would you be willing to defer on just this particular regulation? Although the regulations go through, just defer on this regulation for now. Let us get into session and then take another look at it and see if we can negotiate, reach an agreement. Now, if a member of the General Assembly doesn't want to work and doesn't want to do anything, then you go on as is. So, but that's, to me, that's an offer to pretty good offer, I would think. So, So that would be my ask as chair. Would the cabinet be willing to defer on this one particular regulation until we get into session, January?
The one problem that does create is that that people who qualify for licensure because they hold one of the new certifications would then still not be able to get their license until this one moves forward, because the current regulations are restricted to tests or certifications that no longer exist.
Is that within 39030?
It is.
Okay. And so,
Senator West, is it possible?
Please
is it
proceed.
possible that we accept all of the other changes that were there and defer only for the EIPA?
we would have to defer or not defer on the entirety of 39030. We could accept and go along, allow the rest of it to proceed. All these other regulations that are before us would proceed, and you would just defer on just 39030. So, for instance, 39001, 39040, those would all proceed forward. Any other regulation in front of us would proceed forward, not be restricted. Just 39030. And so, Senator Yates, hop in here.
Yeah, it was just testified to a second ago that in the event that we do defer, then no license can be admitted in there. And if the difference between that, it might be better that we pass some form of it today with the at least the agreed amendments in and things, and then still address it when we're in legislation, as opposed to completely defer. And then, if that is the case, however, I'm looking at it going, since if this has expired that long ago, have we really not been able to license anybody since 2017? Are we just now reading the rule for the first time? Did that expire 5 years after? And why can't we go back to doing what we were doing last month as opposed to today?
Marva, do you want to answer that question?
Sure. I was waiting to see if you. I came on the board 3 years ago, and that's when I had been before the 3 years saying, hey, this isn't. And then when I came on the board, and then had Sarah, we were able to talk and go through that this isn't a nationally recognized test that doesn't fall in line with the statute. I can't speak to what happened before the 3 years before, but I know that when I came on and read the regs and the statutes and became well versed in both of them, I knew that this was an issue.
Have we licensed anybody in the past 3 years since you found that out?
We had to.
Yes. And I don't know, though, that test is just the certification, the name changed, Marva. I don't know when in time that happened, but it's just like, I don't know all the breakdown of there's more than one avenue to get your full license still. And Marva, you know those tests better than I do, but the name that changed. Yeah. Can you explain that?
I believe Senator Yates is referring to the EIPA still. Yes. And why people were still being able to be licensed after 2017, because people have been able to get a full license with the EIPA since 2017, since the national record. Go ahead.
Yeah, I thought his question was broader. I thought he was asking if the board had been able to license anybody. So maybe I misunderstood the question.
The only issue I have with deferring is we're still going to run into this problem, because if you do a carve out, we're still going to ask that you be nationally certified. And again, the EIPA is not a credentialing tool or mechanism
unless there's a statutory change.
Unless there's a statutory change,
gotcha.
Correct.
I can jump in here. I think I can help with this process, move it along. So you have three other options here. Okay, so you could do an agency amendment today, carving out everything but the EIPA provision. You could defer, go into the December meeting, give yourself time to do a proper amendment to do that as well. Or the other option, we allow this to move on to the standing committee You could also do an agency amendment. You can do a committee amendment in the standing committee as well before we get into session. So there's three possible options there. And I'm going to remove my ask. I'll pull my ask back, and I will recede from my ask and allow it to move forward. But once it goes to the standing committee for approval, that'll get us into session anyway. And so I think we're comfortable up here that there will be if someone in the legislature wants to tweak this or change it or remove the nationally recognized standard language, they can. So I'll recede from my ask on that. Any other questions from members? Going once, going twice. Please call the next regulation. Thank you.
Thank you.
Thank you.
Kentucky Housing Corporation, 202 KAR 220.
202 KR 2020 amends Rural Housing Trust Fund loan or grant program provisions to include among the list of applications to be prioritized applications that serve federally declared disaster areas, create new housing supply, would be located in rural areas with significant job growth, would be located in counties shown to have a housing supply gap, or include projects awarded local contributions.
Would you please state your name for the record?
Sam Thorner, General Counsel for Kentucky Housing Corporation.
I promise you your questioning will not be as long as the previous group. Any questions from members on this set of regulations? There are no amendments. Please call the next regulation. Thank you.
Thank you.
Board of Emergency Medical Services, 202 KAR 7210 Emergency, 301 Emergency, 330 Emergency, 401 Emergency, 560 Emergency.
202 KR 7201E, 301E, and 330E amend reciprocity provisions to implement House Bill 57 from the 2024 regular session of the General Assembly. These amendments allow certified emergency medical responders, certified emergency medical technicians, and advanced emergency medical technicians in good standing in any state to be eligible for reciprocal Kentucky certification instead of only allowing reciprocity in states contiguous to Kentucky. 202 KR 7401E amends reciprocity provisions to implement House Bill 57. This amendment allows certified or licensed paramedics in any state to be eligible for reciprocal Kentucky certification or licensure instead of only allowing reciprocity in states contiguous to Kentucky, deletes provisions relating to resuscitation procedures, determination of death, and preservation of evidence consistent with House Bill 57's repeal of KRS 311A 185, and establishes a sunset provision for paramedic critical care endorsements. As of January 1st, 2026, paramedics providing critical care will be required to obtain an advanced practice paramedic license and certification as a critical care paramedic. 202 KR 7560E amends provisions to permit the Board of Emergency Medical Services to temporarily waive paramedic staffing requirements in a Class 1 Advanced Life Support ALS agency upon demonstration of good cause that they have attempted to increase paramedic staffing, and remove the requirement that Class 6 ALS agencies, currently only fire departments that do not transport patients, have to have a licensed paramedic on duty at all times. The temporary waiver of paramedic staffing requirements allowed pursuant to this amendment shall expire on December 31st, 2026.
Would you please identify?
Eddie Sloan, Kentucky Board of EMS.
John Wood, outside counsel for the Board of EMS.
Thank you so much. There are no amendments on this set of regulations. Do we have any questions from members on this set of regulations? Anything you would like to add or say about any of these regs?
Yes, sir.
Okay. Thank you so much.
Thank
Please
you.
call the next regulation.
Justice and Public Safety Cabinet Parole Board, 501 KAR 180.
This regulation is being amended to revise the parole board's policies to align with current regulatory and statutory language, revise agency policies related to supervision conditions, and remove redundant policies.
Would you please state your name for the record?
Cindy Huddleston, Kentucky Parole Board.
Seth Vaughn, Staff Attorney, Justice Public Safety Cabinet. I'm assigned to counsel as the Parole Board.
Thank you so much. There are no amendments on this regulation. Any questions from members? Seeing none, please call the next regulation. Thank you.
Transportation Cabinet, Office for Civil Rights and Small Business Development, 600 KAR 410.
600 KAR 410 amends to update membership and procedures of the committee and make technical amendments to the appeals process.
Would you please identify yourself for the record?
Tony Yusefi, Executive Director.
John Johnson, Assistant General Counsel, Office of Legal Services.
Thank you so much. There are no amendments on this regulation. Any members of the committee have questions for this group? Seeing none, please call the next regulation. Thank you.
Thank you.
Education and Labor Cabinet, Department of Education, 702 KAR 116, 490, 704 3305, 780 KAR 372, and 380. All these regulations do have staff-suggested amendments.
702.1116 is being amended to refine the training requirements to comply with statutory changes. 4090 is being amended to provide a clearer and more efficient process for a district to dispose of surplus property. 704.3305 is being amended to update language to provide clarity and consistency, conform to statutory changes, and add material incorporated by reference. 780.3072 and 3080 are being amended to make updates that parallel statutory requirements and clarify specific policies and procedures. The staff amendments to these regulations amend various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Would you state your name for the record?
Good afternoon. Todd Allen, Deputy Commissioner, General Counsel for the State Board of Education.
Thank you so much. There are staff amendments. Is there a motion for approval of the staff amendments? We have a motion. We have a second. Without objection, it is so ordered. Any questions from members? This set of regulations from the Department of Education. Seeing none, please call the next regulation. Thank you.
Thank you.
Cabinet for Health and Family Services, Office of Human Resource Management, 900 KAR 19.
900 KR 19 amends to change background check frequency from 10 to 5 years.
Would you please identify yourself for the record?
Sure. Jay Klein with the Office of Human Resource Management. I'm one of the assistant directors.
Can you turn on your mic there? Green light.
There we go. Jay Klein, Office for Human Resource Management.
Thank you so much. There are no amendments. Any questions from members on this regulation? Seeing none, please call the next regulation. Thank you.
Cabinet for Health and Family Services, Department for Public Health, 902 KAR 4512. This regulation has an agency amendment.
This regulation establishes the permit requirements for retail sale of hemp-derived cannabinoid products. There were staff amendments approved by this subcommittee at its October 15th meeting, and the agency amendment amends sections 1 and 2 to add clarifying language and delete
Would you please identify yourself for the record?
Stephen Stack, Commissioner for the Department.
Julie Brooks, Regulations Coordinator for the Department.
Thank you so much. There is an agency amendment. Are there any questions or discussion on the agency amendment? Seeing none, is there a motion for approval of the agency amendment? We have a motion. We have a second. Without objection, so ordered. We have before us the regulations from the Department of Public Health as amended by the agency amendment. We do have some individuals signed up to speak against. Would you all like to speak about the reg or let them go first?
If I can have a chance to come back after they speak, I'd be happy to defer to them.
Great. That'd be fine. If Delphia and John Taylor would come to the stand. You can correct me if I've mispronounced your name.
It's Delphia, but everybody knows me as Dee Dee Taylor.
Dee Dee Taylor, okay. If you would Make sure your microphone's on. Both of you state your name for the record, and then please proceed.
Dee Dee Taylor with 502 Hemp and the Kentucky Hemp Association.
And my name is John Taylor. I run a Bahia holding company. It's a CBD manufacturing business.
Okay.
The floor is yours.
Thank you. Thank you for having us today. It kind of amazes me that we're back here today to talk about these rules and regulations regarding hemp products. Natural products that help a variety of people with all sorts of different ailments. I have over 12,000 customers that use my products, and none of them have reported ill effects. Instead, they report how much better they feel, how they are sleeping, how they are no longer addicted to narcotics or opiates, how their life has changed for the better. It probably has a lot to do with the education we provide, unlike liquor stores. But in all honesty, if these products didn't work and help customers, I wouldn't be here today to give testimony. There wouldn't be any bills trying to limit its use or keep people from obtaining the products or putting an undue financial burden on small businesses that sell it, especially when it comes to CBD products in general. On that note, House Bill 544 did not talk about regulating CBD products, so CBD should not be included in any language, nor should CBD be part of the approved adult use products. There shouldn't be a ratio either for CBD products. KRS states that all hemp-derived products are legal as long as the Delta 9 THC is at or below 0.3%. It does not say anything about total THC, which is what these new regs have put in as a total THC, nor does it put in any sort of ratios on CBD products. As long as a COA is available for viewing, that is all that should be needed. The new rule states that all hemp products will now be under this advisory and must be approved by the cabinet. House Bill 544 was for Delta 8. It did not change the law to be anything about total THC. So that definitely needs to be changed. That's page 4, 3D. The federal rules and definition, and even the state definition of hemp, is at 0.3% Delta 9 THC, not total. I'm just reiterating those facts. The $2,000 per year is extremely high for small businesses to pay to be a retailer. I've been in this space since 2018, technically since 2016, and I've never had to pay a fee to be able to sell these products. Most of us, like I said, have been in business for a long time. We didn't have a lot of problems until these products made it to gas stations and liquor stores. So if I'm going to be I'm going to have to pay a fee. I would assume that they all would as well. Same thing for Kroger. They're selling CBD products. Same thing for Walgreens. So keep that in mind. There should also not be 1,000 feet limit from the schools. A lot of these businesses are already selling products. I know there's stuff in the records in the regulations that say as long as you have signed up by December 31st, but that really shouldn't matter if these businesses have already been in business. That should not apply. That should only apply to marijuana, not to hemp products. Keep in mind, these products are two totally different things. The $200 per product per year seems extremely excessive. I can see paying it for one time to have a product approved, but not every year, year after year, especially if nothing has changed with these products. It just seems to be a little bit of a money grab. Plus, I'm a retailer, but I also have my own brand that I'm now going to have to pay another $200 per product to get approved by the state. Again, I don't want to have to pay that every year if nothing's changed with those products. And that also leads to the fact that if I'm paying the $2,000 to be a retailer, and I also distribute my own brand to others as a wholesaler, now am I going to also have to pay another $1,000 to do that as well? So you're talking about $3,000. Another question that came up with these new regs is that how is the state and the cabinet going to impose the $2,000 fee for outside online sellers? Everywhere you look, there are ads coming from other states, other companies, and how is that going to get imposed? People are buying hemp flower from out of state and having it shipped in here, even though retailers like myself cannot sell it. And that has been very specified in the regs that hemp flower is not allowed to be sold. As far as the product registration goes, I submitted one because I wanted to see what all would need to be changed on the labels. I submitted that on September 10th, and I still haven't received an approval process. These regs are supposed to take place come December 31st, but The only thing that's been approved, there's about 90 products, and more than half are nothing but hemp beverages. Speaking of that, when I asked about the hemp beverages, and because he asked me if my lids were child-proof, and I said yes, of course, hemp beverages, they're not. And when I asked him about that, he said, and I quote, "We actually had a lot of discussion about this earlier on in the regulation creation process and decided that the pop tab of a can meets the child-proof requirements. Some producers also purchase the plastic snap caps, but we don't require those." I've got nieces and nephews that are like 3 and 4 years old that can open pop cans. So for the child-proof to be placed just on edibles and not also on the hemp beverages, that's kind of not fair. I just wanted to say a lot of these rules are arbitrary and capricious, not to mention completely harmful to the Kentucky hemp industry and not what House Bill 544 was intended. 21 plus, behind the counter, COAs, and childproof packaging. It did not talk about fees to retailers. It did not talk about restriction of CBD products at all. I implore you to stop this undue burden on retailers and brands. Thank you.
Please proceed.
I'd like to thank the committee for allowing us to speak. I'm going to be brief with your all's time, try not to talk too long. I'm an honorably discharged veteran. I served proudly in the United States Army for 9 years before earning my degree with my GI Bill. I learned about CBD because I became debilitated with epileptic seizures after it was discovered that I had traumatic brain injuries while serving. That was the only thing that helped, and that's what led me to create a business around this. I'm going to speak specifically to some of the amended language. Page 2, line 14, section 1B, removing the term adult use broadly captures every CBD product on the market. And it would include tens of thousands of additional products well beyond the adult use description that would then have to go through the approval process. If you compute that by the $200 per label annual fee, we're running into the tens of millions of dollars just to sell what is non-intoxicating CBD products that are sought out by those that are seeking health ailments. And so again, I would strongly encourage any scope creep of the language to not go beyond what House Bill 544 was designed, which was to only regulate intoxicating adult use cannabinoids. And as far as the fees, I'll say it as a valid actor. I support any financial support that the state needs to have administrative and regulatory oversight. If that's 5, 10, whatever the number is, $12 million, let's come up with an accurate budget that is sufficient for us all to be successful. And as Senator Yates says, we do not want to have lower standards. We want to have adequate personnel. We want to have people that are adequately funded in a department that should be the pride of the nation in terms of quality and efficacy. But the math on the amount of money that is generated seems exorbitant. And so I would just ask that we come to a common consensus on an amount of money that's needed. Let's make that the annual fee, perhaps even charging a percentage of sales so that larger retailers pay a disproportionately larger fee, and that would help the smaller businesses. That's all I really have to add. Again, I thank you all for your time, and I appreciate the opportunity to speak.
Thank you.
Thank you so much on that presentation. What we'll do now is we'll have the cabinet come back up, allow Mrs. Stiglitz, do you want to present? I'm sorry. Come forward. I apologize. I thought you were with them.
I'm with retailers.
You know how this deal works?
Yes.
State your name for the record, who you represent, and please proceed.
Shannon Stiglitz, Senior Vice President of the Kentucky Retail Federation, here representing retailers, including grocers, convenience stores, hemp stores. I wanted to say first, thank you to the Department for Public Health. Since day one, they have worked with us, talked with us about these regulations. We've promoted the need for retailers to become registered. They're giving retailers an additional year. They have made the agency amendments for which you approved today were based on some suggestions and agreements that we came to with the Department for Public Health. But there's this one little sticking point, and it is the $2,000 per retail location licensing fee. If you look at this from what agencies are funding themselves through license fees. Most of the time we think of that about an occupational license. So I looked at the Board of Pharmacy because they permit locations and they license pharmacists. A pharmacy permit fee, and the board inspection staff or the Board of Pharmacy is all required to be pharmacist. It's $150 per permit. We are not opposed to a reasonable structure of fees. I think you know that we have long always raised concern about fees not being in statute. That's a philosophical decision how you want to place it, but we want some reasonableness brought to this. From a long-term perspective, we have concerns this will discourage responsible retailers from getting into this space or from paying the fee and registering. We have about 300, I think it's 316 to be exact, that may have changed, and Dr. Stack can certainly correct me, retailers that have registered selling these products. That really is a significant increase from where we were even a short time ago when it was less than half of that. So we are doing the best we can to get there. That's about $655,000 to start from. I recognize those fees aren't going to start at that point, but I mean, even if we could titrate the fee up, so you pay, $300 the first year and $500 the next, we don't want there to be an irresponsible regulation. We understand they're building a new team around this, but we also need to do that with a reasonableness to ensure that retailers can responsibly do this and we can effectively regulate it. Thank you.
Thank you so much. If the cabinet would come back up, and you've heard the testimony opposed. If you want to proceed, go ahead and proceed. And anything you have to add or
Sure. Thank you, Mr. Chair.
Interact there.
So some of these things we have addressed, not all of them, but some of them already in the agency amendments, which Shannon has just mentioned. The retailers don't additionally have to register a product. It has to be registered once. So if a manufacturer's already done it, then they can sell it. We just need to have someone file the registration so we're aware of which products we're required to supervise and make sure they comply with the requirements that are in statute and then a regulation. We've also, one of the other issues that was addressed, Julie, that we did address that the
total THC, the change that we made through the agency amendment was based off of the testimony at last month's Reg Review Subcommittee, and that does remove that language.
So the point, I'm sorry.
Well, we amended it back to what it originally was, which would be the total Delta 9 THC instead of the total THC.
So could you be specific right there? Like, how did you do it? When did it occur? And there seems to be some confusion there. So,
right.
Yeah.
The agency amendment was filed last week, and so that is what you guys just approved as part of that agency amendment.
Gotcha. So the speakers prior may not have had an opportunity to see the agency amendment. Okay.
Well, and where I want to make
Please
sure,
proceed,
because we're not trying to mislead anyone with the. So that language was changed in response to the feedback. Now there is the issue about sometimes if you have a certain concentration versus what the package can hold. And so I'll give you an example. You can buy some bottles of Delta 8 tincture that could have 30 milliliters in a little bottle like a dropper that could have 1,200 milligrams of Delta 8 in it. And a typical serving might be 20 milligrams or 40 milligrams. So if you think about how, 20 or 40 times that, per dose times how much is in that little bottle, that's a lot of doses in that bottle. If you sell a chocolate bar and a chocolate bar is, this big, there may only be so much in there at a certain percentage. But if you sell a big chocolate bar, you could have a whole lot of chemical in that bar depending on the total size of the package. Does that make sense? And so, yeah. So for that, I just want to make sure we're not trying to misrepresent what we've done in the reg, but we do feel that we addressed part of the concern that was shared, although we may not have addressed all of it. I do feel I want to step back, if I can.
Let's let him finish. I'm really good at interrupting people, and let's finish and then circle back. Make a note, Senator Yates, if you don't mind, and we'll cover it. Please proceed.
So, and I appreciate Shannon, because I believe we feel this way. I think we have worked very, very hard to work with industry throughout this, and I think we've had multiple members of industry testify at various hearings that they are grateful for that partnership. So I think we've really, really tried to work with the regulated community. I want to talk about the fees specifically and why that's necessary. So these chemicals became widely legalized as a result of the 2018 Farm Bill. These chemicals do not naturally occur in the plants, or if they do, they occur at such scant amounts that it is only the chemical concentration of them into very purified and synthetic formulations that render these products. So these delta 8s and 10s and 11s and 12s, those are chemical alterations to the plants that lead to those substances. They're not naturally occurring, or if they are, they're in negligible quantities in the natural plant. So this is a synthetic cannabinoid is what these deltas are. There are no FDA standards. They are not regulated federally in any way. This is a brand new issue fast emerging across the entire United States. At the L&O committee just a few weeks ago, the chair had witnesses at the table who talked about, quote, weed water from Alabama, which is selling faster than boutique beers or craft beers in Alabama purportedly. And the concerns that these have high concentrations of these chemicals and they're not regulated and they're not standardized. So the first thing is there are dangers with these substances. And Representative Rayburn, when she introduced House Bill 544, sat at a table very much like this, flanked by two witnesses from the manufacturing community, and shared either there or when she followed up with me that someone she knew personally had a seizure related to using these substances, and she was very concerned that they be regulated so that there's not impurities and remaining solvents, and that they're properly packaged and labeled, and that there's some kind of testing to verify that what's actually in the product is labeled on the product correctly so that the consumer can be informed about their choice. I don't have any criticisms about the folks behind me, and I don't doubt that with sincerity that they sell these products and educate their customers. But part of this is that these are being sold at gas stations and vape shops and convenience stores. We have 120 counties, which I know you're well aware, the fourth most, I think, of any state. By comparison, in Tennessee, they already have 1,474 retailers registered with them and another 2,529 additional permits pending. That would have them at almost 4,000 permits for this kind of stuff. West Virginia already has almost 1,300 retailers registered. And Virginia has close to 1,000. By comparison, Tennessee has a 6% sales tax on all of this. West Virginia has an 11% sales tax. And in Virginia, there's a $1,000 application fee and a $1,000 permit fee for retailers, but they also have substantial penalties up to $10,000 per violation. And this is all our staff contacting their staff, so that's where we got this information. They have already assessed in fiscal year 24 penalties to the tune of $10.7 million for violations of their regulations. And, you've seen this before. I didn't bring slides, but these are packaged. Here's double stuffed Stonio, Cookie Cat Crunch, Cheetos. You've seen these kind of packages all over the place. Trippy Treats. Here's just peanut butter cups with 75 milligrams of Delta 9 in it. And then here's a comfortably numb tincture. So these packages and what they're selling and representing are incredibly variable. You have no idea what's in these products when you buy them. And we have been assigned by House Bill 544 to regulate this to promote for the public safety. The only revenue source we have been provided are fees. And I'm sorry, I don't have anything out for gas stations, but I'm unapologetic about gas stations selling harmful psychoactive substances with no training and no regulation to oversee these things. And so we're just trying to do what House Bill 544 assigned us by statute. And the means we have to do this is through the fees. The final thing I'd say is Tennessee currently, they told us they have 16 staff. West Virginia has 19. Virginia has 15. They're all, because of the volume of work, needing to expand that. We had, at the start of this, no in-house expertise in the whole state government. There are no standards to follow. It is the creation of entirely new regulatory schema and having to go out and do this. And just a few weeks ago, we went up to a county at the request of local law enforcement because they were selling to underage persons, including a whole variety of products that were clearly illegal. And when we went with law enforcement and engaged constructively with the proprietor, they were so satisfied, they then said, we need you to come to another site we have over here, because they had the same stuff occurring in another location. I just can't begin to express, we anticipate thousands of locations. There is no budgetary appropriation. There is no tax on the products. There is no way to support this. And we conservatively estimate a team of 15 to 25 people will be necessary, and that's a tune of at least $2 to $5 million. If we registered 2,000 sites, that's $4 million a year, right? I mean, so the fees are calibrated to cover what we think, based on bordering states, what they are already currently doing, we anticipate is necessary to support the work. The alternative without the fees is we have no staff, we can't enforce, we can't process applications quickly because there's not people trained and there's not a team to do it, and I won't be able to hire a team to do the work, and so the enforcement will be negligible, if perceptible at all, because I don't have resources to do the work. So again, I am grateful for the individuals behind me. I have no antipathy or animosity towards them. We have an assignment to do, and I would assert they are not uniformly safe. And the last thing is, there was this other product called Diamond Shrooms brand products, and this was in the news this year. This is supposed to be synthetic mushrooms. There were people taking these things and ending up in the hospital. So nationwide, they had 175 illnesses, 33 hospitalizations, potentially 3 deaths. We had 11 people in Kentucky. When we took the list of businesses that the FDA had been informed these were being sold to, because they're not federally regulated either, we went to every business and had them pulled from the shelf because there was a national recall. We then had additional reports that the substances in other businesses, and then when people had injuries and we had to do investigations for the injuries to understand, we found additional sites. So they're all over the place, and the distribution system is not reliable. When they tested these chemicals, and you can see they're all colorful packages, they're chocolate chip cones, cookie cake flavored, and all sorts of stuff, they found more than 8 different psychoactive chemicals that were not disclosed on the labels. They had one had a prescription drug that's FDA regulated and a Schedule 5 regulated substance. And in addition to that, when they tested it, the same product, they tested 4 samples of chocolate chocolate cone cake flavor or something like that, birthday cake flavor. They found 3 entirely different combinations of chemicals, psychoactive chemicals in there. They weren't even the same. So essentially you have bathtub chemists making this stuff in whatever, it might as well be a meth lab. So folks, I'm not trying to impugn folks who choose to use CBD oil or choose to use Delta whatever in a way they feel is responsible, but we're in a state now that has a very highly regulated medical cannabis model that is from seed to sale, that someone who has a medical need can get highly regulated, safe medical cannabis with proper dosing, proper recommendations, whereas we have a situation, why would anyone go that route when they could just go buy something at a gas station that's off a shelf and get it from someone who doesn't even educate about it? Okay, so I thank you for your time, and I just think it's important. We're just trying to do what the statute asks us to do, which is not as simple as just saying everybody's a good actor out there.
Thank you so much. I'm going to start us out with a question, then I'm going to turn it over, I think, to Senator Yates. Just for clarification, I think I may have missed this in translation, but so the $2,000 applies to cannabis businesses selling this product, right?
Retail sites.
Retail sites. Does it apply to gas stations or not apply to gas stations?
Anyone who would sell this in a physical store or sell it, a business in Kentucky selling it by mail.
So if you sell one of these labeled products, you're going to pay the $2,000 for the privilege of doing that.
And Senator West, just so it's clear, if you manufacture a product, then you're accountable for the labeling and the testing, the third-party testing that's required. That's the $250 registration
the initial fee
per product.
Right.
Now, if you're selling it, as long as those products are registered with the state, you don't have to pay a registration for the product, but you have to pay a registration to sell it because we're going to have to go out and inspect it.
That was clarified in the agency amendment.
That's the way that's always been. But what was not clear was it said that product registration language showed up in 2 locations in the different regs, which created confusion. We agreed with that feedback. So we removed it where it was not relevant in the retail space and put it over in the manufacturing space.
Gotcha. Senator Yates.
Thank you, Mr. Chair. And that did help. That's what I was trying to interrupt earlier. That helped clarify because I know we just did it took the amendment and when you were explaining it, because I saw the $250 fee, I thought it was 2 different times because it looked like it was going to be really a $2,000 fee plus a $250 fee for each individual product that they had in there. And but a little bit on the total THC in the CBD oil, and I'm going to show some of my ignorance on this one. I'll do my best to keep up, but I do understand that I guess some of the there's minimum amounts, trace amounts of THC that will show up in some of the CBD oils and things like that. So I was concerned about the before the staff amendment, but it looks like you guys took that out completely. That's what you were telling me?
Yes.
Okay. When we talk about the psychedelics and stuff, that's just one of my big push about making sure that that we're being fair with these things, because what I've learned is the prohibition doesn't really work. And that when we have a really small team of 5, 12, 15 people throughout the state of Kentucky, what happens are good actors, they fall in line, they pay the fees, and then we have a proliferation of bad actors who cover the shelves in like bath salts and things that are actually killing our kids. And so I do worry about that. And potentially it sounds like the funding here would be, the only funding you're getting is through fees. If we're wanting to enforce people who are selling products, psychedelic, and I know some of the mushrooms that we're not even considering today that really were just toxics that weren't even mushroom, it sounds like that maybe we need to be able to budget you some money so that you can have a 100-person team that can actually enforce, because it's the people behind you and those that are trying to come in and compete and pay the fees, license, do everything else, they're going to be undercut by the person across the street who's not doing any of that. And the stuff that you're showing on your piece of paper, you could, I mean, I guess we could call bad actor after bad actor all day long. Like you said, you went from place to place to place. Legislation, the laws that we pass today, all that's going to do is get the good actors to fall in place. Those bad actors who are already selling psychedelics and bath salts and hallucinating mushrooms and stuff, I don't think they're going to care a whole lot. So it sounds like the other issue is if we're really serious about this, we're going to need $10 or $12 million of real enforcement, making sure we don't have kids overdosing on these type of drugs that they're going to be getting. Because if they're a bad actor and they're already going to sell this stuff, then why wouldn't they sell it to children as well? But I do think that it is important that we do have basic access, and I think that sometimes that I didn't know a whole lot about it, but I did understand that like some of your Delta 8s and Delta 9s are a whole lot better for people than sometimes of your Klonopins and your other anxiety medicines, depending on what it is, and less addictive. I know that with the medical marijuana, we have made that so restrictive that a lot of anxiety and things like that, they won't even qualify for. So we are going to have a large segment of the population that are still looking for alternatives. So there's got to be some kind of balanced approach on here. As far as the fees being excessive for each location, I do have some issues with if we're carrying it all in the backs of the mom and pops. That if I can have these national companies that are worth tens of millions of dollars and they're paying the same $2,000 as opposed to someone who's trying their best to be a holistic place that has the CBD and the different things in there. One is got their kids are on the Little League team and playing around and trying to make ends meet, and the other is this national model that is owned outside of a different country, invested into it. And so I didn't know if maybe we could do this in a way that's based on the sales as well. It's a little bit more fair that if somebody's selling $200,000 worth of product each year, that maybe they pay a higher fee as opposed to just everybody a set fee. There's some proposals.
So, Senator, I thank you for that. I mean, it is complicated. Let's be honest. I mean, it really is complicated, and it's not standardized. And unlike alcohol, where there's a highly regulated, standardized system, if you go buy a can of beer, you know what you're getting. And there's plenty of people get hurt by alcoholism. So this is not a puritanical approach I'm advocating here. It's just there is no standardized system and no approach for this. I don't think we have any other place for retail place that charges fees based on volume of sale. And the problem is, as you mentioned, A lot of these places are not accustomed to reporting that way, and we don't have an infrastructure to do it that way. It is a problem with out-of-state sale, but it's outside the reach of the Commonwealth unless we ban the intrastate shipment, but then you have federal, interstate commerce challenges. So it is really difficult, but I do want to put in context here. A little bottle of tincture can cost $29 to $49. Now, there could be other ranges. I'm not expert at this. I know what I can find when I even looked online and can see what's available. This is and I get it. There's folks who use these because they feel that they're treating or helping other symptoms. But the biggest part of this business is recreational use. It's people who are going out to buy something along with their alcohol or some other drug. And so for that biggest use, that market has incredible elasticity. You can charge 40 or 55 as well as you can charge 49, or 35 as well as you can charge 30. And I think if there were some dissuasion from gas stations and places like that selling a product that could be, because we don't know what'll happen here. If you think about this, if you smoke a joint, typically you're getting some sort of dosage of marijuana, delta-9, tetrahydrocannabinol. These things are incredibly concentrated, massively concentrated. So we really don't have good evidence, and they're clearly, I'm an emergency physician. Even when I was practicing before I became the commissioner, we had people come in who had hyperemesis syndrome, vomiting repeatedly because they had used so much cannabinoid product that they started to have adverse harms from it. How these things are either develop other dependencies or problems over time is to be determined, because these delta-8s and others are synthetic substances. They're not naturally occurring in the product. We don't have a history of decades and decades or centuries of use of smoked cannabis. So I really do worry as an emergency physician, not just as a public health professional, about what sorts of addiction-related problems we might be creating because we've thrown open the door, to a whole new world of synthetic chemicals that we're letting be sold freely. So I still remain somewhat unapologetic about the fee, because I don't think a gas station needs to sell this stuff to stay in business, all right? And I think the public danger is significant enough. Last thing I would share is we received a new law this year on kratom. And there's a whole slew of these things, those magic mushroom things, the diamond shroom. That wouldn't be kratom, at least not based on what they said was in it. And it wouldn't be cannabinoids. There's a whole body of work, as I think you've correctly identified. And there is a need for a team. And when we have 120 counties with all sorts of rural areas down small little lanes and roads, I think we all know how the sheer labor intensity of going out to all these places. And then once there's a system in the public, it's a constraint. Because right now we're only pretty much in a complaint-driven stance, because I don't have a team to do this stuff until I can have a revenue source to sustain them. When the law enforcement asked us to come out, they were relieved, and they said, we're going to tell all our friends, because in the neighboring counties and everything, because there's people who've had lots of places they want us to go visit, but we just don't have the resources to do it. So we will work with what the legislature gives us, but I just want to be honest about it. It's a task we've been assigned now, not just for hemp-derived cannabinoids, but also for kratom, and no team and no resource. And I'll be happy if you want to give someone else the work, and then we don't need any more resources. But we've been given it, and we would like to do it in good faith so that the legislature and the people of Kentucky feel well served. Thanks.
Following up a little bit, so I don't know if they sell it or not. This is just a hypothetical example. CVS, Walgreens, let's say they sell this product and they have 150 locations. How would that entity be charged in this?
Per discrete retail location. So whatever their
per
physical
location.
Per location.
So a large corporation would be paying a lot more based on if they had multiple locations.
Well, based on the number of sites. But,
right.
but it doesn't address the volume issue that Senator Yates raised. They may
Right.
sell
But
a lot more volume. But
if they had more locations, they are paying a much higher fee. And when you get a product in, okay, and you're going to review it for the $250 fee, what are the criteria used to review to do that review? Is it simply in the list of things in 544? They have to have this amount of this. They have to have this level, point whatever. Is that what you're going
So
by?
this was
or-
in a regulation that went through the committee last month.
It may
Right.
be in this one. So it is in the labeling. One of the things I look at is the labeling. And that's a lot of what they're addressing is the labeling clear? Does it, those products that he was showing, the Cheetos, would it be appealing to children? So they're looking through all of those. They're also looking at what is the serving, what is the amount per serving. Are there any other items that
I'm
are
more
listed
concerned. I'll help you out. I'm
Okay.
more concerned with what are you basing your percentages on? The statute itself,
Yeah.
the levels. So whatever's laid out in the statute, those are your criteria
Yes.
you're using for the dosages in
Yes.
the bottle.
Yeah, for the dosages.
Yeah.
Yes.
And that then there's an absolute restriction that it cannot have greater than that 0.9%.
Right. So my point is
0.3%.
the agency isn't coming up with this on their own. This is straight out of KRS.
To the extent that we did anything different, do we constrain at all the total quantity that can be in a single package?
I don't believe so.
Okay.
No.
Okay.
I was
Okay.
gonna say I don't believe so.
That's my only question. Any other members have questions on this? Okay. At this time, I'm going to bring them back.
Sure.
And let them respond.
No. I totally agree with the bad actors in this field. Okay. We have been doing this for a really long time. My husband was one of the first processors in this state. So we have led that path on making sure that your products are tested, making sure that the label is what is in that bottle and what it should be. And I've taken that education side with my retail space to make sure that people knew how to use these products. Now, when Delta 8 came on back in 2020, it surprised me as well because we've always been over the health and wellness aspect to the whole hemp plant. But knowing how these products help, it changed my mind about things, not to mention the law, because the law said 0.3 Delta 9 THC. But the one thing that really infuriates me is that it's not truly a synthetic because they use CBD that is naturally occurring in the plant, and then it is a conversion process. So it's not just made up out of thin air. It is an actual cannabinoid in the plant. I do not sell HHC. I do not sell THCP. Those are some cannabinoids that I won't touch because I know that they are not what my customers should be using. And they're not, to me, healthy. There's some things in those. I had one person tell me that they were high for 3 days off of THCP. So I don't sell it. Now, that's my own personal preference. I know other retailers, they sell everything. I never sold the diamond shrooms either because I did not know what was in them. And that is a problem. And I agree with that. However, the one thing about adding the CBD products, and I'm talking CBD oil full spectrum that has that 0.3% to now having to be approved and paying that $250, that is insane. Keep it to the adult use cannabinoids, which is the Delta 8, the Delta 9, THCV. I'll even throw CBN in there, but just strictly CBD products, I don't think that those should be part of that mandate for the $250 approval. I also do have my own brand, so I do have to, my manufacturer that makes those is in Wisconsin, so I will have to pay for my own brand to be approved by the cabinet. And I'm fine with that. But again, I think that should be approved one and done, not yearly. So those are kind of my takes on that.
And I'm just going to add quickly that I don't think I've ever been more in agreement with someone that was the opposition. We completely support the cabinet's position and that they need an adequate budget. How do we do that? And what is it, whether it's a percentage of sales, we're open to creative suggestions to give them the resources that they need. We completely agree that with 10, 12 people, they cannot adequately survey 120 counties.
It would almost make more sense to impose a sin tax on it and let the consumer pay for it instead of the mom and pop companies. And many people have said that before. You add an extra 3%, that would probably cover everything. I mean, that's what we do for vapes. We pay an extra fee for the vapes that we sell, And we're also licensed with the Department of Revenue, and I pay $100 for that, and then $20 for Jefferson County. So that's much more reasonable. And then we charge an extra. We pay $1.50 for each vape.
And just to add, not to go down to a rabbit hole, but in time as we develop this industry, actors like myself and my wife, we adamantly support packaging that does not attract children.
Mm-hmm.
There are people that are making things that should absolutely not be sold. We encourage a sufficient budget that if the department wants to actually pay for certificate analysis to validate a test result. There's a big problem in our industry right now that certificates of analysis are being forged. Mm-hmm. Because they're expensive, and to pay for a real one costs a lot of money. So there are people that have gotten really good at Photoshop. There was a major lawsuit that was just settled where a company was found, a publicly traded company, manipulating test results. So again, anything we can do to help the cabinet be functional and effective in their role, we're all for.
And
I think
please know we were actually here, and John was actually here giving testimony with Representative Raymer about that. So we are all for it. 21 and up, behind the counter, away from the children. I completely agree. But don't make these so hard for people that can't get medical marijuana to use these. He takes a 6,000 milligram of CBD oil for his seizures. It is the only thing that has helped this man. So to make those obsolete, you would in turn be hurting a lot of my customers. And that's just on the CBD side.
But again, 5-10 million, whatever this young man needs to do his job, most of the industry is 100% behind that.
So a couple questions that I must have missed in translation. So you talked about the CBD products need to be pulled out. Are they not included in House Bill 544?
They were not.
And just for clarification, the regulation was originally structured in that we were looking at CBD was, if you go back when we first looked at hemp in Kentucky, going back to Commissioner Comer, those products were legalized at that point in time. The Department of Agriculture had regulatory authority over them. It still does in many respects. House Bill 544 directed the cabinet to regulate those products, CBD hemp-derived products that have an intoxicating effect. Mm-hmm. The regulation makes a distinction. If you sell exclusively CBD, you do not have to be a registered retailer. Fully admit we asked for that because it would be superfluous. They've been doing it for a while. They're listed with the Department of Agriculture, and the Public Health agreed to that. But what changed from the statement of consideration, that when the statement of consideration was filed, is that instead of only exclusively requiring products to be registered that have an intoxicating effect, Delta 8 as we commonly refer to it, it requires all CBD products to be registered with the Department for Public Health and pay that. That's going to encompass a whole host of products that you probably do see on
so your
shelves
opinion is
everywhere.
that the regulation in that case superseded the intent of House Bill 544. Is that?
I don't know that I was giving you an opinion. I was just laying out how it changed. I don't know that I have that level of expertise to give you that opinion, but
they took all of hemp products, not just the adult use products, and now they've just made them all into one.
We just want to make sure there's clarification.
But
and that was just recent.
Is that not what 544 said, though? We were looking at 544 a second ago, and I thought it said all. Did it say all?
Adult
use.
All adult use. Okay, that's your distinction. Okay.
Mm-hmm.
Or intoxicating hemp
Gotcha.
products. I think that's how the cabinet distinguishes it.
Back to the fees. We talked earlier about the $250 per product. Is it still your contention that it's going to be charged every year?
Yeah, and I would prefer one and done unless something is changed in that product.
We as a manufacturer, we might change the label every 5 to 7 years based on marketing needs, and the request would be is that if there's no changes and the product category is the same, certificate analysis hasn't changed, can we only have that applied when changes are made?
Yeah.
Again, instead of consideration.
Okay, I'm sorry. We may have to have the cabinet come back up. I thought the agency amendment actually did a one and done
If-
250 fee.
if
I
you-
thought that's what was stated.
If
in
they
test-
did, I'm not aware of that.
Maybe I missed something. Could you all comment on that? It did. Okay.
Actually, I was looking at something else. Give me just a minute.
Take your time.
No, if it is one and done, that would be ideal. I would,
Mm-hmm.
We weren't aware of that.
So just a point of clarification, the cabinet has authority to regulate ingestible and cosmetic cannabinoids under KRS 217-039 that was passed in 2021. So we do
Separate from HB 544.
Yeah,
Gotcha.
yeah, separate from that. And if you'll give me just a minute to look up the product registration.
The fees.
Sorry, we're way down at the bottom.
I understand.
So the 902 KAR 45021 is the hemp-derived cannabinoid product registration, processing, manufacturing, storage, and distribution requirements. And in that regulation, we do require for processors and manufacturers to register yearly to receive a yearly permit, and it does say that they are required to pay the product registration fee. It is not clear in reading this at this time if that is an annual or a one-time only. So, and part of it's because I'm reading it on my phone and don't have the actual copy with me.
Oh, absolutely.
Oh, sorry.
One thing, you're in the other reg, though. You're not in today's reg, right?
Yes, I'm in a different regulation, not the one being
That reg already went through ours and is now going to be at the standing committee, which will happen in you don't do them in December, right? It'll happen in January.
No, it could be December.
Okay.
But I'm not sure the schedule of that particular one.
So that issue, if we need to have a follow-up discussion, it would be the next committee. That will be the opportunity, since it's already gone through this committee, I think, because that's not.
Yes,
in the
and the
reg.
same thing here. If these regulations move along, they will go to the standing committee as well, and so, which may or may not meet in December.
Yeah, that's my concern.
And you have 90 days, so it will be into session, and so there will be time to look at that. And so I think I can help with the discussion up here anyway. I think the big hang up here personally is with the fee, whether it's a one-time fee or if it's a yearly fee. I think it would be good if we could for sure clarify that.
Yes.
And do some type of an amendment or something of that nature to clarify that. Definitely would help them if it was one time rather than yearly. That would help with the pain. But you want to comment on
Well, so Mr. Chair, I think if we're talking about the product registration fee, and if we said you had to do a one-time product registration fee, and as long as the product did not change, any changes to packaging, content, anything, there had to be a new application because it's not the same product. I think we can discuss offline and use the next committee hearing, because that reg, it's not in today's reg, I don't think.
No, it is
So
not.
we could use the next committee hearing, and you all
Sure.
can pass that along to the other chair, and we can be held accountable for that at the next hearing.
Yeah, we're here every month.
So for today, for today's reg, other than what we agree to here in front of you, is for today's reg, the question would be the $2,000 retail fee, which again is I kind of need to build a team so I can start doing the work.
Right, and on that particular issue, to me, both sides have made their case. You know, the cabinet's made their case. You've made your case here today. So on that, committee will stand at ease. Go ahead. So at this time, we've had full testimony. I think everybody's up here is good. We had a full dialogue. Do any members of the committee have any questions or motions on the regulations that are before us right now? Seeing none, just a reminder, if nothing's done here, no motions are made, it'll move on to the Committee of Jurisdiction. You'll have another bite at the apple. You can ask for a committee hearing on the regulation in front of that committee, the Health Services Committee, and then you can discuss whatever you want to discuss and make an effort there. I would, as committee chair, I'm going to ask the cabinet, if you would, to come back next month, draft a regulation dealing with the $250, the fee, the one-time, clarify that it's a one-time fee per product. Obviously, that would be a separate regulation that's not before us, and that's my ask.
Just to clarify that, because so it's, I don't think we're going to dispute whether we do that or not.
And you can be specific with the language if you want to craft it to make it
right.
Yeah,
but it's already in the other reg that's going to the other committee. So drafting a new reg wouldn't fit the regulatory schema because we already.
I think you can adjust it.
Yeah, we can adjust the other one, but
yeah.
Mm-hmm.
So an easier and quicker way to do it, maybe to do it in that standing committee.
That's right.
You could either do a standing committee amendment, or you could do an agency amendment.
Mm-hmm.
Right. Now you'd have to do a fast turnaround on the agency amendment, but we're talking about a couple sentences. I think would take just clarify. I think that clarification would take care of these guys on that one particular issue, and would be kind of an olive branch.
We can definitely do that. We can work that for the next committee in the other reg that now the next committee will have to vote up for, to let it go through.
I appreciate that. That's my request as committee
It's on their agenda
chair.
for Monday.
Oh, okay. Well, will they take something from us this short? It's on their agenda Monday.
Yes, yes, and I can call the committee chair and give them notice of that.
Okay.
Get to work at it.
And I appreciate that. That'll. I know this is a little bit unorthodox, really, that we're doing it this way, but that'll help. That'll help them, and that'll move the process forward. Any other questions on this particular topic? Seeing none, please call the next regulation. Thank you.
Thank you.
Department for Medicaid Services, Division of Health Policy, 907 KAR 2035.
907 KR 2035 amends for consistency with House Bill 6 from the 2024 regular session and increase the personal needs allowance from $40 to $60 to reduce the amount of the community spouse's income that is to be applied monthly to payment for cost of care of an institutionalized spouse.
Would you please identify yourself for the record?
Good afternoon, Jonathan Scott, Chief Regulatory and Legislative Officer, DMS.
Thank you so much. There are no amendments on this regulation. Any members of the committee have questions on this regulation? Seeing none, please call the next regulation. Thank you.
Department for Community-Based Services, 921 KAR 330, 922 KAR 150, 160, 1470, 290, and 2120. 922, 1470, 290 and 120 have staff suggested amendments. 922, 150, 160, and 290 have agency amendments.
921 KR 3030 amends to delete language related to drug felonies and update the application for SNAP for consistency and to add a question about internet expenses that is now an allowable deduction.
922-1050 is being amended to update language regarding state-funded adoption assistance, allow for a reduction in assistance payments in certain instances, include reimbursement of funeral or burial expenses for a medically complex child who is adopted, increase the amount of adoption expenses the cabinet will cover for a special needs child, expand options for making annual contact, and make technical changes. The agency amendment to this regulation amends Section 6 for clarity. 922-1060 is being amended to update language regarding federal adoption assistance and eligibility criteria for youth recipients, increase the amount of non-recurring adoption expenses the cabinet will cover for the adoption of a special needs child, require that contact with the adoptive family be made on an annual basis while they continue to receive financial assistance, and make technical changes. The agency amendment amends Sections 2 and 8 for clarity.
922 KR 1470 amends to include checking the central registry for prospective employees and update the central registry check request form as a result of passage of Senate Bill 145 from the 2024 regular session. The staff amendment amends that relates to paragraph to comply with KRS Chapter 13A. 922 KR 2090 amends to exempt instructional programs meeting statutory requirements from Child Care Center licensure as a result of House Bill 491 from the 2024 regular session, and makes changes to address federal non-compliances identified in a recent federal monitoring visit and updates material incorporated by reference. 922 KR 2120 amends to address non-compliance issues identified during a recent federal monitoring visit. The staff amendments for 2090 and 2120 amend various sections to comply with KRS Chapter 13A. The agency amendment for 2090 amends Section 9 to include drills and the requirement for a written plan and diagram outlining the course of action in the event of a natural or man-made disaster, including to add a requirement to provide this to all staff, volunteers, and visitors, and amends Section 10 to include staff, volunteers, and visitors under the Director's requirements to ensure development, implementation, and monitoring of Child Care Center plans, policies, and procedures, and the supervision to ensure implementation.
Would you please identify yourself for the record?
Rachel Ratliff, Staff Assistant for the Department for Community-Based Services.
Todd Trapp, Director of the Division of Family Support within the Department for Community-Based Services.
Andrea Day, Director for the Division of Child Care.
Thank you so much. There are staff amendments. Is there a motion for approval of staff amendments? We have a motion. We have a second. Without objection, is so ordered. There are also agency amendments. Are there any questions or discussion on the agency amendments? Seeing none, is there a motion for approval of the agency amendments?
Second.
Motion made and seconded. Without objection, is so ordered. There's been a lot of discussion. The people getting up here and moving around and talking to people, there's been a lot of discussion on one of these regulations. It's KAR 3030.
Mm-hmm.
And
the department would request to defer to allow us for an opportunity to answer any questions and provide some background just to make sure that committee members are satisfied with the amendment to the regulation.
Thank you so much. So there is a request from the agency to defer on 921 KAR 3030. I make a motion that we accept the deferral request.
Second.
We have a second. Without objection, is so ordered. The regulation is deferred. So before us, we have, in this set of regulations, all the regulations other than 921 KR 3030. Any questions from members on this set of regulations? Seeing none, please call the next regulation.
That concludes our agenda for regulations. Under other business, Department of Corrections 501 KAR 6410.
This regulation establishes the following departmental policies on inmate life and issues: missing or stolen inmate property, personal hygiene items, marriage of inmates, legal services program, board of claims, inmate grievance procedures, sexual abuse prevention, and lesbian, gay, bisexual, transgender, and intersex inmates.
Thank you so much. Any questions or comments from members of the committee on this regulation from the Department of Corrections on 501 KAR 6410? Representative Frazier Gordon.
Will this be coming before the committee, or is?
That's an interesting question. That's why it's on here. It will not be before the committee today. Request was made to the Department of Corrections to testify on to the committee today on this, and they refused. This has been deferred, so they're still working on it. We sought, this committee sought information on this set of regulations, and we were told they did not have enough time to testify, although I think they had testified before on this, and we're working on it. So that's where this stands. We are attempting to bring them back in front of the committee next month. Thank you. Any other questions? Senator Thayer, I think, has a comment.
Next month will be my last meeting, Mr. Chairman, and I hope that the department is paying attention today, because if they come with a reg before this committee that asks the taxpayers of Kentucky to pay for transgender surgeries for people who have committed crimes and are paying their punishment in our jails and prisons, that they probably want to rethink that before the next meeting, because I'll be in a mood, I can guarantee you. Thank you, Mr. Chairman.
That is duly noted, and it is now on the public record. Any other questions, statements on this regulation? Any other business?
The next meeting of the Administrative Regulation Review Subcommittee is currently scheduled for the 10th at 1. However, there is a conflict with that, so we were looking to find a different time to meet. Would that morning work for anyone, or perhaps Monday the 9th?
State the date again.
The 10th, December 10th in the morning, or the 9th. So that's Monday the 9th or Tuesday the 10th. You're okay with that?
Say the time again on the.
Let's
start one date at a time. So let's go 9th. What?
I think the 9th is the preference. 1.
Could we do 2?
2 on the 9th. Okay. Is there a problem with the 10th? We had it scheduled for the 10th at 1, correct?
We did.
Yeah, I can't make it.
Got it. Okay. Yeah. What about 10 at the 10th at 9 a.m.? She's got a conflict. Okay. Let's.
If it has to be 1 o'clock on the 9th, I can make that.
How about 2 on the 9th? She's got a conflict on the 9th. I'm sorry. So.
Which we wouldn't be getting into the DOC stuff till later.
Yeah. Let me look at the 11th. The caucus retreat is the 11th, I believe.
There's a way to get you invited.
This is he's at CSG on the 6th.
That's part of what we're running against, are the caucus retreats, and the
CSG is on the 5th and 6th.
Yeah.
9th at 1 o'clock?
The 9th.
9th at 1 o'clock?
Earlier on the 9th?
I had court in the morning.
1? Representative, or Senator? Okay. We'll try not to have this meeting as long as today's. So let's shoot for 1 o'clock on the 9th.
All right, Monday.
Monday the 9th. Yeah.
And we will send reminders as well. Yes. So, thank you all.
Any other business to come before the meeting? This committee's adjourned.